You're watching BCTV. We're all about Brantford. You're watching BCTV, Brantford Government Television, a service of Brantford Community Television. This program is brought to you in part through the support of the town of Brantford.
Okay, welcome. We'll call the June 5th, 2019 Board of Selectmen meeting to order. Item 1, to approve the Board of Selectmen minutes of May 15th, 2019. Can I get a motion?
Make a motion, we approve?
Accept, second.
All right, all in favor, say aye.
Aye.
Opposed, abstentions, item carries. Item 2, to consider and if appropriate, approve the initiation of condemnation proceedings with respect to Crescent Bluff Avenue. We have Attorney O'Hanlon here to representing the town.
Good evening.
Good evening.
My name's Ted O'Hanlon from Robinson & Cole, representing the town in the question of whether to take the Crescent Bluff Avenue by eminent domain. Let me give you a little bit of background. The proposal is to take the entirety of the road, to include a reasonable buffer on either side for access and maintenance and repair, and also the grassy area at the south end between the cul-de-sac and Long Island Sound. There's already a drainage pipe that goes from the cul-de-sac and daylights to Long Island Sound through that grassy area. But the idea is to take by eminent domain the entire parcel. Beechcroft LLC is the name of the owner. They secured a ruling from the Superior Court about 6 years ago that it held valid title, and that the Crescent Bluff Avenue is not a town road, as it had been treated for over a century. Beechcroft apparently had obtained assignments of interest from heirs to an historic owner, and had obtained the title that way. Beechcroft, prior to 2000, did not have any involvement with the property. The question followed an adverse ruling with in any litigation. Do you take an appeal? Or in the question of a municipality, do you exercise your power of eminent domain? And our recommendation has been to do the latter, to take it by eminent domain, because that provides a certainty as to the cost of it, and it avoids the time involved in an appeal and the uncertainty of an unfavorable result. The trial ruling was not favorable. The standard on appeal does not favor an appellant who's lost at the trial level, and so you just move away from the entire litigation context. The exercise of eminent domain is a perquisite of the town's sovereignty, and so you have a lot more flexibility and a lot more freedom to do what you perceive to be in the best interest of the town. And so that has been our recommendation, is the the litigation that has continued to surround the road and the rights to the property around it. The town has been able to stay out of that and to save considerable amounts of time and effort for its staff in getting mired in that. So I think this is a sound way to proceed. The town has a long interest in that road. It's paved it, it's maintained it. There's a sanitary sewer and drainage structures underneath it. And it's been included for years in the state list for town road aid. So this route provides certainty and it avoids undue expense. Unlike a number of other roads in town, and forgive me, I'm not from Brantford, so you may be more familiar with this, but there's one unique aspect about this from other similar situations that may be claimed to be similar. This is not a property owners association that has title. This is an LLC controlled by a single individual. And so the idea of taking it back by eminent domain not only avoids the expense and the uncertainty, but there will be no strings attached anymore. There have been instances where the town has had difficulty with access and with signage on the road. We've been able to work amicably with the owner, but But again, anytime that you've got a single owner and someone without the interests, with their own interests as distinct from the neighborhood's interests in mind, it makes it that much more problematic. So again, our recommendation is for all these safety considerations and for the, there are 30-plus homes along the road, private residences. You certainly have an interest in preserving the value and the use of the private property, the residential stock in the town. And then with respect to the grassy strip, the access to the sound for the public. So that's our recommendation. My understanding is that this is the first step in the town approval. There's a town approval and process under the charter, and then there's a state approval by statute. I will be principally involved in the state approval, but I'm here to present the issues as it moves through. I guess it's the Selectmen tonight. It will be there's been a referral, 824 referral to planning and zoning. There's an RTM consideration. Ultimately, there'll be a Board of Finance because there's obviously a cost involved, but that's something that'll be handled down the road. And even under FOIA, the town has an ability not to talk about negotiations and costs of real estate transactions at this point. But what I want to assure you is that the town, in the exercise of this eminent domain authority for a public purpose, has a lot of flexibility. The state process of valuation requires us to meet with the owner and see if it can be worked out. We've already done that. We'll do it again. If you can't work it out, the statute requires you get 2 independent appraisers, which we've lined up, and they do an appraisal of it, and then there is an averaging of those appraisers, and that determines the value. And that's the end of the issue. If they accept the value, then the amount paid into court becomes theirs. If they don't like the value, again, they have an appeal process through the court, and the court would assign it to an experienced judge or a judge trial referee for resolution. So the entire process is intended to enable the town to do what it perceives to be in its interest with respect to protecting the road, the people along the road, the public access to the sound, and in a way that doesn't involve the uncertainty and the expense of litigation, the possibility of an adverse result, and then, in other words, to manage your destiny. So that's, in sum, why we recommend that this avenue be pursued, and that the taking of Crescent Bluff be accomplished.
Okay, thank you. Is there any questions that anyone has or statements? I mean, I would just say, I think, the town has, as you stated, there's many reasons. It's in our interest to ensure that this Crescent Bluff Avenue remains or is a public road that has been the town's position as stated for many decades, if not close to a century. There's many reasons why I think we should ensure that this remains public access, and I accept your recommendation as being the best avenue to ensure that we protect the town's interests. I don't know if there's any other comments or recommendation. I will just also mention for the record, and this will be part of the record, the Board of Selectmen has received a letter from the Pine Orchard Association in strong support of the town moving forward with this condemnation process. And as I stated, that will be part of the record if anyone has interest in seeing that letter. With that, I'll entertain
I'll make a motion we approve the initiation of the condemnation of Crescent Bluff Avenue.
second.
Second.
All right, any further discussion? Any further discussion?
Public comments?
Sure. Thank you.
Step
Yes.
aside.
Yeah, if you don't mind just sticking, yes.
Thank you.
Good evening. I'm attorney David Hardy, and I represent Beechcroft LLC, the owner.
of Crescent Bluff Avenue. My client just received notice of this particular agenda item yesterday afternoon, and it has asked me to make a statement this evening in opposition to this initiative because, in our view, this is a completely improper use of the eminent domain power. There are more than 100 private roads in the town of Brantford, dozens of which, like Crescent Bluff Avenue, lead toward Long Island Sound. My client's property is no different than any of these other many roads that are situated in the town of Brantford, which the town also paves and maintains. And in our view, what we have here is the town singling out this particular road for confiscation at the urging of a small and select group of citizens advancing private interests. And in our view, taking this property to satisfy the wants of this small group and using public power to attempt to resolve decades of private litigation in which this group has been unsuccessful is an abuse of that power. And my client intends to respond to any eminent domain initiative as such. Tonight is the first time we have heard that there was a proposal before the town to take the lawn at the end of the road. To the extent that the town maintains a pipe in the lawn area, it doesn't need to acquire the lawn area in fee. It can acquire an easement to maintain the pipe. And why is it that this particular point of access to Long Island Sound in this lawn, as opposed to any of the other points of access along Long Island Sound in the town of Brantford, why is this particular property being singled out to establish this new point of public access to Long Island Sound? That the town is considering heading down this road, the road it has been down before, the road that led to Tabor, we believe is irresponsible. And if the town decides that it does want to move forward with eminent domain, Beechcroft stands ready to respond in the same manner that the town saw with respect to Tabor. Beechcroft is open to discussions with the town, but those discussions should not take place under a threat of eminent domain. Thank you.
Thank you.
Got my notes on my iPhone here. So, good evening. My name is Rich Colbert. I am a partner at the law firm of Day Pitney, where I have practiced real estate litigation for too long, several decades.
Use the microphone, please.
I sure can. I guess I also own the home at 2 Halstead Lane, which we just remodeled and is on the water, and is the road that is parallel, and the next road to Crescent Bluff. I guess I want to start by saying that I'm appalled that the Pine Orchard Association sent a letter to this town asking that it take a road within our association by eminent domain. A simple review of the Pine Orchard Association charter and bylaws would reveal that that is a breach of the Pine Orchard Association's obligations to its residents and members of the association. The letter to the town literally begs this town to come in and take a property for not a benefit to the Pine Orchard Association, but for a benefit to the public at large and to this town. That is not what this association was established for, and it is grossly outside the bounds of their authority. The other remarkably improper basis for the eminent domain letter you received is to settle a private lawsuit. Eminent domain is not a law that is established to settle private lawsuits between private individuals. And I'm surprised that Attorney O'Hanlon, when he made his comments, highlighted the fact that that would be the benefit and the purpose of this taking. That's improper. The Pine Orchard Association was established, like every other association, to protect the land and the resources within the association for the benefit, the exclusive benefit, of the Pine Orchard Association residents, not the town and the public at large. The Pine Orchard Association Board is duty-bound under its charter and its bylaws to act in the best interests of the Pine Orchard Association residents, not a group of people on a particular street who seemingly have friends on the board or previously served on the board and who are looking for help in fighting their personal battle with a person who owns property on that street. The obvious reason, in my view, that the Pine Orchard Association has sent this letter is because their claim in the litigation with on Crescent Bluff is frivolous. In that lawsuit, as you probably know, they claim a prescriptive easement over the street as well as the grass area for the benefit of all the residents of Pine Orchard Association. The grounds for that are, one, that a few sundry people walked a loop over many years down Spring Rock and over Crescent Bluff. And the Pine Orchard Association, for some reason, believes that that was on behalf of the association. That is absurd. That is not action on behalf of the association. Secondly, and importantly, they claim that, or
I do just want to state, not to interrupt you, just to be clear, that, as you know, this has been a longstanding issue and a longstanding position of the town. So although I did reference a letter of that came through from the Pine Orchard Association, this is not at the request solely of the Pine Orchard Association, but why it's before this body. I just want to be clear on that.
I appreciate that comment, and I will get to why I think that the town shouldn't be doing this as well. But with all due respect, I find it remarkably ironic that this meeting has happened within approximately a month of you getting that letter from the Pine Orchard Association. The second reason that the Pine Orchard Association claims that it has a prescriptive easement over this street is because throughout the history of the Pine Orchard Association, repairs indeed have been made to walks, sidewalks, and walls within the association. If you take the time to read the minutes from the Pine Orchard Association, they date back to the late 1880s, as I have done recently. You will find that those records are replete with evidence showing that those repairs were not for the purpose of adverse or prescriptive easement purposes. Those records make clear that the work that was done was for safety purposes, for beautification, because the owners at that time, and this is back in the 50s and the 60s and the 40s, when hurricanes and so forth were coming, didn't have the wherewithal to make those repairs. And the records make very clear that the repairs were being made because they believed that those owners would not object to that work being done. In addition, there are comments in those records that indicate that the Pine Orchard Association was renouncing any liability for the work that they were taking in doing so. That is not prescriptive easement action. That is not adverse action. That is implied permission to do work, and it doesn't support their claim. So it's my belief that because they are not going to prevail in their action, that they're now asking the town to step in and bail them out of what I believe was a very poor legal decision on their part to get involved in that lawsuit. And I believe that is entirely improper for this town to serve as the pawn for the Pine Orchard Association to get them out of this lawsuit. The taking, by the way, also serves, and this gets to the town, it serves no public use for this town. It doesn't give access to anything that's commercial, which is typically what these takings are for. It doesn't give access to any schools, hospitals, or otherwise, which is what the law and the statutes require. Moreover, the taking serves no logical purpose. Crescent Bluff runs parallel to Spring Rock Road. Spring Rock Road is already a public road. That road is hardly overburdened by the public coming into Pine Orchard to use the beaches. There is simply no reason why we need another road that is public in our association, which is against our charter and bylaws, when we have a road already that's public, that the town people can use if they so desire. The Pine Orchard Board's unanimous approval of the letter that they sent to you indicates a gross misunderstanding of their obligations to the Pine Orchard Association residents. I believe that an injunction can and will be filed against the association to order them to cease and desist from seeking this town to take that road by eminent domain. I will be involved in that lawsuit if I have to be. A mandamus action will be brought ordering the Pine Orchard Association to defend any efforts by this town to take that road by eminent domain, because that is the Pine Orchard Association's obligation under its charter and its bylaws from 1903. Finally, a mandamus action will be brought to remove every person from that board, because they obviously have no idea what they're doing, and they have no idea what their obligations and who their clients are, so to speak. I also want to correct an important factual error in the Pine Orchard Association letter. That letter indicates that the road was public before Beechcroft bought its property. That is absolutely incorrect. That road has never been public. In order for a road to be public, the owner of the road, under the law in Connecticut, had to have, when they subdivided that property, dedicated the road formally to the town. That never happened. And as a result of that, the town has never been the owner of that road. And the town, and the law is clear, that the town, by maintaining it or putting easements through utilities in the road, cannot gain ownership of the road by doing that. It's not allowed under the law. And I don't know if you're aware of that, but that is the law. To the comment that Beechcroft's attorney recently made, I'm aware that Beechcroft is quite willing to enter into agreements that are customary throughout the state of Connecticut with all towns and with the utilities that serve those towns, to sign basic and standard maintenance and indemnification agreements so that the town would have access whenever it needed, and the utilities would have access whenever they need it to go down that road to do what they have to. The litigation on that street, and this is my final comment, the litigation on that street should not be resolved by strong-arm tactics by the Pine Orchard Association that clearly has no confidence in their lawsuit, nor from this town. The way it should be resolved is the way that they're trying to resolve it right now, through mediation efforts with a Connecticut Superior Court judge. I'm aware that there have been at least 2, maybe 3 meetings to try and resolve this matter. And if that doesn't work and people are not reasonable, which they should be, then it should be decided in a court of law by a judge who makes a determination based on the facts when everyone has an opportunity to present their evidence to the extent they have some. Those are my comments. Thank you.
Thanks.
Thank you.
All right, any other comments?
I just have a question, maybe for the attorney from the Beechcroft. What stops the owner from putting up Jersey barriers at the end of the road on any given day?
I mean, that sounds to me like a hypothetical.
It is a hypothetical.
That I'm not prepared to answer, but one that really has no connection to the reality of the situation.
Can I get the question again?
Yeah, I'm just wondering, hypothetically, what if the owner decides to put Jersey barriers at the beginning of the road on any particular day?
For the purpose of stopping who?
Anybody?
Well, people on the street have a right-of-way over the street, so they couldn't do that, and they would have a right-of-way over the street.
So that would include public safety also?
Pardon?
Does public safety have the right to that road?
The public, no, right now.
No, public safety, fire department, police department? They have the absolute right to go down that road at any time?
I believe, sure, that makes perfect sense, obviously.
Okay. Thank you.
Okay, if anyone would like to address the board, you just remind you have to come up to the, I know you're just answering a question, I know. TV can't pick you up. Sir.
I'm Robert Wheeler, a resident of Crescent Bluff Avenue. I would simply like to challenge the lawyers as to their understanding of
Mr. Wheeler.
Beechcroft.
Mr. Wheeler, just be sure to address the board and.
Thank you.
Thank you.
Thank you.
Thanks.
A motion for contempt on June 17th, 2014, against the town of Brantford by Beechcroft for giving the gas company permission to install a gas line into the residence at 37 Crescent Bluff Avenue. As a defendant, Beechcroft demands a fine of $5,000 plus court costs for the town action. Court denies their action on September 9th, 2014 by Judge Sheridan. I claim that this is an action on Beechcroft's part to justify total sovereignty over the street. Thank you.
Thank you.
Any other comments? Okay.
Just one brief follow-up. I would just say to your other question, sir, to the extent the town has a concern about access for public safety, fire, first responders, police, et cetera, obviously that's something that my client would be willing to have a discussion with and make an agreement with the town that those sorts of accesses would be permitted. So I just wanted to put that on the record.
Thank you.
Okay, thank you. Okay, any other comments? Okay, hearing none, I just like to, one final comment from me is that I know Attorney Hanlon did mention that it is a multi-step process that we'll be going through. This is just the initial step. So, with that, all in favor, say aye.
Aye.
Opposed? Abstention. Item carries. Thank you. Item 3, to consider and if appropriate approve a request from API Sycamore LLC and Victor Casella for a license to construct a paved driveway and related lawn area in the adjoining town right-of-way off of Sycamore Way.
Good evening. For the record, James Perito from Halloran and Sage with offices in New Haven. I'm here representing Mr. Casella and AP Sycamore LLC, which owns number 8 Sycamore Way.
Good evening. Good evening.
Mr. Casella's company is American Polyfoam, and his entity has purchased this lot to construct a warehouse and related office building on it. And just to the north of our site, there's a town stub of a road, which was originally laid out when the subdivision was put in place for this industrial subdivision, so that if in the future the land to the sort of northeast was developed, the town would be able to put in a town-regulated road out through there. Right now, there's nothing there. There's some shrubs and piles of dirt from our neighbor, but otherwise it's just there. So what we'd like to be able to do is have a license on this property to maintain a paved driveway and associated grass on either side of it. It would do a number of things. One, it would frankly allow our truck traffic through the site to be a lot easier in terms of turning and access through there. It would eliminate some of the disturbances on our parcel, and some of the large trees that are there would not have to be removed, because the loop would have to go around our building, and it would come, as you can see on the plan that's filed. There's a couple parking spaces to the west side of the building. It was sort of cut down and through there. So I've included a draft license. It went to the town attorney. We obviously would provide insurance. We'd indemnify the town. The cost of all the installation of the driveway and the grass would be borne by my client. We've also had a comment from the town engineer who said, well, what's going to happen to sort of the area from where the driveway is to the back portion? There's sort of a small area there, which right now has some small shrubs and grub and trees and things like that. We'd be happy to say that, you know, we'll maintain that. We'll use like a grubber to keep it under control so it doesn't create sort of a too much growth there, so it would be an issue for the town in the future. And it would terminate, this license would terminate at such time in the future that the land behind is developed and the town wants to put through a town road. Obviously, the license would terminate, we'd be obligated to sort of reattach our driveway in accordance with town standards at that point. And I think that's pretty much it. I'm happy to answer any questions. If you need a larger plan to see, I have larger plans.
All right, thank you. And I know we've had similar agreements in the past, and this just, as you stated, is really at all the cost to develop the property owner. And in the event that the town was ever to eventually do a road through there, it would be no cost to then pay the owner for the improvements that they made. We
No,
would
that's,
remove it and
yeah,
develop the road.
that's right. I mean, we basically, town would put in its road, or
And you would
if,
just connect to the road.
Correct.
So this actually, this is,
and as you know, this is the first step. We have to come to the Board of Selectmen, then it has to go to the RTM, get referred out, and through that. Our hope is we'll be submitting a site plan that shows the drive, all of the drive on our property. We'll let planning and zoning know that, we've asked for this, and if this would be granted by the town through the various bodies, then, we're going to show them the alternative plan that shows the driveway through there. That way, we can proceed with the site plan, so we'll be in time to get the foundation in before the winter, since it's, it's happening faster than we think.
yeah. All right, so can I get any further questions or comments?
Make a motion, we approve.
Second, any further discussion? Hearing none, all in favor say aye.
Aye.
Thank you.
Thank you very much.
Okay, item 4, to consider and if appropriate, approve a request from Dan Gregory, Superintendent Wastewater Pollution Control Facility, for a bid waiver for the disposal of the pre-treatment waste and award a 3-year contract with a possible 2-year extension to All American Waste contingent upon favorable opinion of the Board of Finance. Gentlemen,
Hi, gentlemen.
how you doing?
Doing good. Yeah, I would like a bid waiver for the pretreatment removal waste from the treatment plant. We've had All American Waste now for over 8 years. They've done a pretty good job. They've stuck to their original contract price for years. They haven't gone up. They said they stick to it again. What we haul is special waste, so it needs a permit to be dumped at Manchester landfill. So that my department takes care of the permit. We get a permit letter that okays All American Waste to dump our waste there, and then it gets buried. So that's in their name. But we like the service. He fixes our dumpsters when they need it, if they're broken. Not too many people fix them because of what they're filled with or what they're left over with, which isn't too pretty. So they fixed it a few times for us. And I know with your approval, then I'll just have to go to the Board of Finance and get their approval because it's a multi-year contract. We do about 2 loads a month, and they're about 8 tons a load, and the dumping fees, they're about $100 or more at Manchester. We don't get a bill from Manchester, we get charged through All American. So basically, when we get the bill, it's the hauling fee and the tipping fee. And that's the way the contract's been written.
Okay.
And they've been doing this for 8 years for the same price?
Yeah, and longer. Basically, it was 2008 when we started it. Yeah. So it's been a while.
Yep.
We do approximately 20-something thousand, 24,000 a year. And that depends on the waste.
I have no problem. I'll make a motion, we approve.
Second? Yes. Second. Been moved and second. Any other comments? Hearing none, all in favor, say aye.
Aye.
Thank you.
Cool.
Item 5, green use, to consider and if appropriate, approve a request from the Community Dining Room Incorporated for the use of the town green on Tuesdays, June 18th through August 20th, 2019, from 5:30 to 7 p.m. to hold Tuesday night dinners on the green. Can I get a motion to approve?
Second.
Been moved and seconded. Comments? Hearing none. All in favor, say aye.
Aye.
Appointments, Clean Energy Ad Hoc Committee, Bob Babcock to fill a vacancy left by Frank Gasparo.
Motion to approve.
Moved and seconded. Discussion. Hearing none. All in favor, say aye.
Aye.
East Shore District Health Department, Susan Addis to fill a vacancy left by Lois Shine Lear, term to expire February 28, 2022.
Motion to approve.
Second.
Then moved in second, discussion, hearing none, all in favor say aye.
Aye.
Item 7, reappointments. Board of Police Commissioners, Joe Marcus and John Sasulis, terms to expire January 30th, 2022.
Motion to approve.
Second.
Moved in second, discussion, hearing none, all in favor say aye.
Aye.
Green Committee, Cynthia Jasek, David Colley, Bonnie McCurdy, terms to expire May 31st, 2022.
Motion to approve.
Second.
Discussion, hearing none, all in favor say aye.
Aye.
Inland Wetlands Commission, Sandra Kraus, moved from an alternate to a full member to fill a vacancy left by James Setti, term to expire May 31st, 2022.
Motion to approve.
Second that motion.
Discussion, hearing none, all in favor say aye.
Aye.
Peter Bassman and Rich Grinalch, terms to expire May 31st, 2022.
Motion to approve.
Accept.
Moved in second, all in favor say aye.
Aye.
Parks and Open Space Authority, Judy Miller and Greg Chiocci, terms to expire June 30th, 2022.
Motion to approve.
Motion to accept.
Any discussion? Hearing none, all in favor say aye.
Aye.
I don't think we have any correspondence. Any other business? Just want to first, go ahead, Joe. Well, I was going to welcome you back.
Thank you.
It's great to have you here.
Absolutely.
I would just like to extend my personal thanks and my family for all the good wishes. Get well, cards in the mail, plants at the door, shake hand at the door, ringing my bell. I love it all. I consider it an honor to be on this board and work for this town. And I was quite sick for a while, but we fought it. And we won. And for those who don't know, my name is Joe Higgins. I am from the Bronx. We operate way different than up here. So I'm getting an education, but at the same token, Jamie, to you, Jack, board members, membership, thank you again. God bless.
I have a feeling there was somebody named Angie that helped a lot more than she's taking credit for.
I knew he would embarrass me. Jack and I go way back before I even knew Branford existed, and he was one of my fans till now. Yes, my wife over here, my executive officer, I would have never made it without her. I swear on everything that's holy. And the work ethic she's doing, she can have my job. But thank you very much, Ben.
Welcome
Thank you,
back.
Jack.
Welcome
For
back.
embarrassing me.
All right. Well, with that, motion to adjourn.
Second that.
Motion to adjourn,
All
sure.
right, all in favor, say aye.
Aye.
This program was brought to you in part through the support of the Town of Brantford. Watch town meetings and other videos on demand at BrantfordTV.org.